I'm a user too. You're here for me too.
Yep.
It'll be fine. It's just, it's getting back into it fine.
What time do we be there, 8:30?
Yeah.
Okay.
I think we should be there at 8:30 just because we're tall and I get in.
Okay. Are we meeting at your house then at like 7?
Yeah, I could do that.
Probably makes the most sense, right?
I think so.
Is Becca coming on Friday?
Yeah.
Or she's sending somebody?
No, she's coming.
Okay. And I can't bring the dog, right?
No,
No, probably not.
probably not.
Who's gonna sit
Who's
there?
gonna, yeah. Yes, yes,
Confusing.
yes. This. Everybody's getting in right now. Are you guys doing anything?
They asked me what I want to do, and I told them I want to go to Ireland.
That's like,
Okay.
you're like, stop asking me questions. You don't like my answers.
I don't like spells. Lisa always said, I don't know, $2,000 from mom's true. You just take that off and you could go get a job then.
Yeah.
Go find some project you can do.
I don't think there's not.
Just get your job.
That doesn't sound fun. That doesn't sound like something I want to do.
Nothing paid for it.
Yeah. Does he have any more jobs on there?
She actually has somebody else because she wanted to done now.
Okay. He needs to raise it. I know he's trying to get people in. I'm sure that's sort of the idea behind it.
Mm-hmm. I don't think he's done anything for time, you know?
That's surprising.
I think this time he's like, I want this.
She's been asking since he was still alive this year.
Hi, is he still in there? Okay, well, you asked him if he wants me to read him in court. Okay, because last time I did, he yelled at me. Oh, don't? Okay. Okay, bye. All rise, please.
You may be seated. Please call the case.
Your Honor, now calling People of the State of Michigan versus Galloway, case number 2019-272-265-FC.
Good morning. Please state your occurrences for the record.
Good morning, Your Honor. Danielle Russo-Bennett on behalf of the people.
Good morning, Your Honor. Danielle Hegman, talking people.
Good morning, Ellen Michaels on behalf of defendant Floyd Galloway.
Good morning. We are here for the defendant's a motion to disqualify the Attorney General's office. You filed a reply. Did I miss the order where I allowed you to file a reply?
You did not.
Okay. Why should I accept the reply?
You should accept the reply because this case is very unique in the questions that are presented to the court. It's a case of first impression with regards to the way that the privileged information was handled, the way it was passed on, the way it was further passed on. We're in uncharted territory, and I believe further explanation as to one more thing is because the case was passed from one judge to another judge. There's a lot of catch-up just by any human being taking on the amount and volume of information. So a reply in this situation further clarifies the issues and the interpretations of what's been happening over the last 2.5 years.
People?
Your Honor, I think MCR 2.119A2B is very clear. Reply briefs are not permitted unless the court does so allow. I would ask you to strike the reply brief. There was no stipulation by the people, no agreements that there should be a reply. I did read it in case the court did address it today, and I will say that I don't think it was, quite honestly, relevant. There were words in there that did not apply to the order that we have here, and so I think that the court should just strike it, not consider it. Thank you.
You made a compelling argument why I should consider the reply. Had you actually filed a motion with the reply based on the corporal, I think you folks are learning that I am meeting. I will follow the law as it is, and I expect exemplary briefing in this kind of case, so I will strike the reply. Make your argument.
Thank you so much. If I may grab my documents.
You're welcome to be at the podium if you like.
Thank you. I will be there.
You can be seated if you like. Standing is better for your health, but you're welcome to sit.
If I could have a moment, Judge.
You may.
I'm just going to pull it up right here. Thank you very much for your patience. The legal basis for our argument as to why the Attorney General's office should be disqualified from prosecuting this case is that the government intrusion into the attorney-client privilege has risen to the level of a due process violation. The legal basis is a constitutional due process violation. My client, Floyd Galloway, is entitled to a fair trial. That's all we want here, is a fair trial. Over the years of this case, whether it was the handling by the police, the handling by the prosecutor's office in this case, my client's rights have been violated. The court, the trial court, has ruled that multitudes of evidence will be suppressed because of this violation. We believe that the Attorney General's handling of the privileged information that came into its possession further violated my client's rights and tainted the prosecutors who came into contact with that information from prosecuting this case. There are many prosecutors in the state of Michigan that can come into this case, look at the evidence, and try the case. There is nothing special about this Attorney General's office that they need to be the prosecuting agency to try this case.
Okay, I am going to interrupt you because the one thing I am unclear on is they weren't always the prosecutor, right?
They were always the
They
prosecutor.
were always the prosecutor.
Oakland County Prosecutor's Office denied charges. Then the Farmington Hills Police Department and the Attorney General, I don't recall who initiated that contact, but that contact was made while Oakland County was still asking for more investigation into the matter
So they were
before charging.
investigating it, and then the Attorney General intervened and said, we're taking this case.
They took the case, yes.
All right. Do you have authority under the court rules or jurisprudence that says that when a statewide Attorney General is disqualified, that a local prosecutor can, I mean, you make it sound like I just get to I don't. Who gets to do that? Do I say Oakland County, you have to take this case? Do I say to Wayne County, is there a superintendent control taking over a prosecutor's office and say you take this case? I mean, if I disqualify myself, there's a process for that. The chief judge, we have a local administrative court rule, and I disqualify myself, and it bounces around to the next person, etc. If we disqualify ourselves as the bench, it goes up to the Supreme Court Administrator's office, and then they assign it to another judge, another circuit. How does it work here?
That's a great question.
I try to ask great questions. I don't always ask great questions, but I try. So what
Excellent.
happens?
That is a great question. So, what the position that we're in then is, let's say they're disqualified. We've got this case. Who then takes it over and who makes that assignment? I would have to research it. I can't imagine that this has never happened before. Cases get special prosecutors.
You're asking me to do it, and you don't know what the remedy is?
Up until this time, we believe that Judge McMillan ordered the Attorney General to pass the case on to an untainted prosecutor. We believe that's the remedy that Judge McMillan put in place and is suggesting. We're comfortable with that the Attorney General pass it on to an untainted elected official, a different prosecutor.
We're here for your emotion.
I'm sorry?
We're here for your emotion.
Correct.
Okay. And normally when somebody files a motion, there's a brief. The brief gives the legal authority for the remedy that they're seeking. And you said you'd have to research it. Even if I granted the motion today, which I'm not inclined at this point since you can't tell me what happens next.
I can tell you. We stand on Judge McMillan's ruling that the Attorney General pass the case on to an untainted prosecutor. That's what we suggest happens. That's what Judge McMillan said to do, and that's what we stand on. That they pass it on to an untainted elected official from another county.
Tell me why the isolation protocol that the Attorney General has already established is not sufficient.
The purpose of an isolation wall is the people who are in possession of tainted information are put into an isolation wall to be isolated from the case. So what could have happened here is the Attorney General's office created this group of 15, 20 people that they cite in their filings, and then they give it to somebody else in their office or an untainted prosecutor in another county. That's how an isolation wall works. The tainted people do not participate. They're set aside and they pass it on. What happened here is they're saying, we have now isolated all the people who have the tainted information. We are going to continue to litigate. We're not going to let anybody else know what this tainted information was, so people don't dislike him. I mean, there's no legal reason why it doesn't make sense what they did. An isolation wall keeps the people who have the information from the case. They created an isolation wall for the people who have the tainted information to, in a bubble, litigate the case. That's not what an isolation wall does.
But my understanding, okay, you have we'll call them the tainted prosecutors for the moment. I know your definition of prosecutor, my definition of prosecutor, Judge McMillan's definition of prosecutor may be all different. But we have individual assistant attorney generals who are human beings that know this information. And nobody else in the Attorney General's office knows about it. And now I've made my ruling in connection with, just elaborating really, McMillan's ruling on the suppression and the other issues. And so the question becomes, now that it's time to litigate the case, the non-tainted assistant attorney generals are going to take the case over. Why doesn't that work?
There are two ways that I look at it. One, that if we did it that way, who do they report to? Dana Nessel, in the chief of the litigation unit, is in the group of tainted people. So if they were assigned another untainted person to report to oversee the litigation, that would be okay. How that would get, I guess it would be good faith that Dana Nessel and the chiefs don't get involved, but these untainted people do it. That is an option, and that is something that would be more acceptable than doing nothing. I think the best outcome is that it goes to a different agency.
Okay. Thank you. What's your response?
I could actually answer your question as it relates to how cases get reassigned, if
Okay.
you are still interested in that.
Yes, I am.
Okay, so we're going to kind of bifurcate this because as the criminal bureau chief, my job, at least one of my responsibilities, is to sign off on special prosecutor assignment requests. So that process is slightly different in the sense that a prosecutor themselves is saying, I have a conflict, I'm asking the Attorney General's office to say, yes, there is in fact a conflict. And in that process, it goes to the prosecuting attorney's coordinating council to try to find one of the other 83 elected prosecutors to accept the assignment and move forward with the prosecution. Whether that's at the investigation stage or if it's a case that's already being litigated in court, wherever that process is at. This process is slightly different because it's not a prosecutor saying they have a conflict, it's a judge saying the office has a conflict and is ordering the prosecutor off the case. In the past, that same process has always been used. I'm unaware of any case where a judge has said, AG's office, Oakland County's office, Wayne County, Macomb County, you guys are off, and I'm going to appoint a prosecutor, because there's nothing in the law that allows for that. Even on a special prosecutor assignment request, where a prosecutor is saying, I have a conflict, there is no ability for the AG's office or for the PAC, is the acronym for the Prosecuting Attorneys Association, to say to another county, you are taking this case. It is all voluntary.
Right.
And so if this court were to grant the defendant's motion to bump the AG's office off this case, my recommendation would be to send it to PAC and have them then find another office that is able to actually bring it on, to take it on.
Thank you. You're welcome. Clarified.
Judge, and in that same respect, we are asking the court to not do that. We are asking the court to not disqualify the entire Department of Attorney General. What I think about was interesting from Ms. Michael's argument is she started by saying our legal basis for this disqualification is, and I don't mean to repeat myself over and over, and I know I really cited it a lot in the people's response, and I've cited it in the previous motion that we had, but there was no legal authority cited in the actual brief. The only case that was really cited was People v. Joe Lee, which is the basis for the earlier suppression from 3 years ago, and that does not contemplate or even speak about disqualification and mitigation of the sort. And so she cites that it's this government intrusion, deliberate government intrusion due process. But we have to really think about what we're talking about here. We're talking about a privileged memorandum that was unwittingly given to us, to the defense, to the entire case, from a polygrapher's attorney who filed it on his own volition. It wasn't the police who procured that information. That's what we're talking about here. So when we're talking about this deliberate due process government intrusion, we're talking about another attorney who filed this. And so it's kind of like, and I hope I don't sound glib, but it's kind of like the game of hot potato. The idea is I tossed it to you guys are left there standing and holding this memo, and now you're off and everybody in your office is off. And so what I think is interesting about that is there is no authority really cited here as to why the court should consider this. I think your questions have kind of dictated how I maybe should do my response here. The cases that the people cite, People v. Davenport, People v. Doyle, In re Osborne, they all talk about these factors that the higher court sent back to the trial court, said, no, you have to look at these things before you simply say, hey, your whole office is off the case. You have to look at the size of the office, the mitigation that was done, the effective written screening procedures. That's People v. Davenport that talks about that. What was done to make sure that what we know, what's in our head, as Ms. Michaels wrote in her motion, does not go and taint other prosecutors. And so what efforts have been done? And that is our isolation wall. And I know Ms. Michaels said she doesn't think that's enough, but it isolated any of those who had information about that and left a large office and a large number of criminal trial prosecutors available that have no knowledge of this memorandum, have no notice of it.
Let me ask you a couple questions.
Yes.
First off, how big is the office?
650 lawyers.
All right. Probably the biggest law firm in the state, right?
Biggest law firm in the state.
All right. So my next question is your protocol, your isolation protocol, talks about this memo, but there's information. I mean, there's opinions, there's transcripts, there's motions, there's a wide orders. There's a wide range of information that comes from the tainted tip. Why should I be confident that your isolation memo stops all that? Because it just seems to talk about the memo. It doesn't seem to talk about all the information.
And like you said, Judge, you ask great questions, and I think I'd like to take that kind of bifurcate that if I can.
I didn't say that, somebody else.
I'd like to bifurcate that if I could. When you're talking about the opinions and the orders and the briefing that have to do with this Attorney Arthur Weiss privileged memo, that's what we're talking about here. If we're talking about that, that would be incumbent upon us to redact all that out, take that out, make sure that is also isolated along with the memorandum, any reference to this memorandum, anything that would include any information about the memorandum. But when you talk about the evidence that has been suppressed by this court and by Judge McMillan in 2022, that's a little different when we're talking about the tip and the evidence that was suppressed, because the defense is allowed to use that as a shield. They're not allowed to use that as a sword. And so if you suppress a confession, for instance, in a Walker hearing, I know about that confession. I know it exists. Like Ms. Michaels said, I can never forget about that. But the normal course of procedure is not to recuse me off a case and say I can't prosecute it. I'm expected to follow the court's order and not use that evidence and not let it come in. That is my job to do that, and I'm expected to follow the court's orders. I'm not recused or disqualified. My office is not disqualified simply because I know a confession exists that I can't use. It is same in this respect. There is a whole slew of evidence that exists in this case and I just want to give the court a hypothetical. What if the defendant took the stand and testified and perjured himself and was inconsistent with what has existed and has suppressed? They cannot use that suppression as a sword. And if you have a team of new prosecutors who have never known of the suppressed evidence, they're going to sit there blindly and just cross their arms and not be able to object or even do a good job, an appropriate job in prosecuting this case, because that would really be fundamentally unfair. So when I think we're talking about what needs to be taken out and what needs to be redacted out and kept from the quote-unquote untainted prosecutors, the suppressed evidence is very different than this privileged memorandum that's got privileged communications in it. They can't use the tip. They can't use that evidence. But they have to be aware that it existed. Otherwise, they are at a significant disadvantage in prosecuting this case. The defense is free to do and say whatever they want, wholly inconsistent with reality. And that's really kind of a disingenuous ask, I think, from the defense to say they get to be in the dark, but I get to know. And so I think it's very different when we're talking about the suppressed evidence and the memorandum. The memorandum is privileged information. We cannot use it, and we cannot pass it on. So in that respect, I think it would be our duty to make sure we take out your
How is
opinions.
the tip not also privileged?
It has been deemed privileged, which is why the evidence had to be suppressed.
Right.
Again, I just think that they can't use it. They can't know about it. And Ms. Michael's arguments all along have been on this Arthur Weiss memorandum that purports to have communications that we are not allowed to have, and that gave a version of events. As Ms. Powell Horowitz testified to at the evidentiary hearing, it was an alternative version of facts, so to speak. That's the privileged information that's been put out there that defense has cited that we should not have been privy to. And that is what should not go to the untainted prosecutors. But I think if you start talking about, the Walker hearing and the suppressed confession, i.e., as a hypothetical, to suggest that a prosecutor can't be aware of the case as it stood, and to make sure,
Just give me a
sure.
sec. Just give me a sec. I don't know that I read her argument so narrowly. I mean, the argument is, you're saying it's only about the memo. And obviously it's addressed by the memo, but it also says, while the office may not intend to omit the memo during this prosecution, or call Mr. Is it Hop or Hope? Hop. Mr. Like a rabbit, I have to remember that. Mr. Hop to testify about it. The ultimately fatal problem is that there will never be a way for the materials to be expunged from the memories of those who have read all or parts of it, have discussed it, or who have incorporated sub salento. I'm sure I said that wrong. While considering strategy and tactics, even strategies and tactics of responding to defense motions, preparing for making an argument about any issue before this court. An advocate drafting pleadings, briefs, and other documents, preparing for pretrial matters or for direct and cross-examination of evidentiary hearing of trial witnesses, brings the process all of his or her knowledge of the law generally, as well as the knowledge of the criminal law procedure, conversations or readings about specific case, and so on. Trying to tease some parts of the fund of knowledge and resources at the fingertips of such an advocate away from the rest and try to purge it would be a fool's errand. I mean, so it seems like it's not just about the memo.
And I think that's probably where we disagree, because as a practical matter, I don't even, as a prosecutor, see how a prosecutor prepares 20 to 40 police witnesses to get on the stand and make sure that they don't testify to something this prosecutor sitting here has no knowledge of. How do you object? How do you ensure? How do you gatekeep and make sure that your witnesses are not saying something, because we're talking about a large police department and several other police departments that are all aware of this evidence. How do you ensure that a new untainted team properly prepares that case going forward to make sure not only is something said on the stand that's not perjury, but that your own case in chief is not violating Judge McMillan or your Judge Warren's court order by bringing up things that are now suppressed? And I think that that is almost an impossible task to ask a prosecutor completely in the dark to what has been suppressed to be able to then also ensure that Officer A, B, and C doesn't
So let's play
testify.
this out. I deny her motion. How does your what happens next in your office?
Your Honor, we would gather up our discovery that we have as a team. We would redact out any of the court orders, any of the opinions, any of the briefs that cite to the memorandum, that talk about the memorandum, any motions that Ms. Michael has filed that attach the memorandum itself. Any reference to the memorandum and its substance would be wiped from the file to ensure that it's being passed on to untainted prosecutors who don't get any of that privileged information. We would also consult with the prosecutors, make sure they are aware of a list of all the evidence that is suppressed in this case, that cannot be used, cannot be referenced. And so we would also talk to the cops, make sure the police, have them talk to the cops, ensure the police don't bring up this information. They have to be, I don't want to say in tandem with their witnesses, but they have to ensure that their officers aren't even trying to slip something in that they're unaware of. So there would be these prep sessions that they could have with the officers to let the officers know this list of evidence is something you cannot talk about at trial. And I think that that would be the beneficial way on going forward. And I think it's really interesting the language that's used in some of the cases that were cited in the people's response. One was a federal case, but it was a federal case out of California. I think it's U.S. v. Bolden. And it cites to what a drastic, I think that's the language it used, what a drastic measure it is to push off an entire office off a case, that it should be something that trial courts hesitate to do. And I say that because when Ms. Hagman-Clark cited to the 650 attorneys, we have the ability to do this. And I hesitate to say this, but I'm going to say it anyways. I think that's what Mr. Galloway's banking on. He's banking on somebody within our office, within our criminal trials division, being able to pick up a no-body case and go forward and prosecute it. And I think it's his hope that it'll be passed to somebody, to a different office that might not have that capacity. And so as I hear about these arguments, well, there's nothing special about the Attorney General. I don't know what legal argument that is, that there's nothing special about us, except that it's our case, and we charged it, and we used our discretion to charge it on a no-body situation to go forward. We believed we had sufficient evidence to do so. So the nothing special about us is really not for the court's consideration. However, the factor the court should consider is we have a large office of experienced attorneys who could pick this case up and go without being tainted by that privileged information.
It doesn't matter where the case lands. The issue about what cannot be given to the prosecutors is going to exist if it's with your office or with any of the other 83 prosecutors.
I agree.
What's your response?
Yeah, Judge, I'm sorry, Ms. Michaels, I don't mean to interrupt you. You had asked a question earlier, and my colleague just reminded me of it. You said, Ms. Michaels said, who do they report to? Who do the untainted prosecutors report to if they can't report to Dana Nessel? They would report to her deputy AGs.
I didn't ask that, but
the criminal. I
she
apologize.
asked that, and I know you can work it out. I'm not worried about it.
Yeah, they report, just for the court's own edification, they report to the deputy AGs, Mr. Pochin and Manning, and as well as the Criminal Trials Division Chief, Robin Liddell.
Thank you. Okay.
Great, thank you.
I'd like to address the argument that the AG just made regarding comparing what happened in this case to a confession given without Miranda warnings, or evidence taken where some other procedural violation was made, therefore evidence is suppressed. This is so qualitatively different. This is a situation where pages and pages of alleged statements by my client were given to law enforcement, who should have taken it and held on to it and buried it. Instead, he passed it on to another government agency, who then took it, hid it as an anonymous tip, so there was bad faith behavior there, hid it as an anonymous tip, and used it and hid the source. We have to remember, this is how we got here. We didn't get here by some police officer being sloppy. We got here by deliberate intrusion into the attorney-client privilege that was then hid. It's the cover-up that is almost as bad as what happened. We are now addressing the cover-up. the Weiss memorandum that we keep talking about was part of the cover-up, where Arthur Weiss was defending the polygraph operator who tried to protect himself from being exposed. So as part of that cover-up, he now presents to the government, hey, wait a minute, I am a protected, snitch is the only word that comes to my mind, a protected source, therefore my identity can't be revealed. And moreover, only when there is exculpatory information that comes out does this person's identity get revealed. So this information was given to the Attorney General's office as a way to save his own neck. And the attorney representing him put forward information that he had no business publishing to the prosecuting government agency. At that point in time, the government agency, the prosecutor's office, should have taken that document and shoved it in a file cabinet, never to be looked at or never to be seen. But they didn't. They kept it in the file for anybody to see, look at, read, who was bringing themselves up to speed on the case, handling the case. And it was our position, and we argued this to Judge McMillan, that we laid out facts showing that their strategy and thought process in arguments that they made in appellate briefs reflected knowledge from this Weiss memorandum. That's the taint that was furthered in the prosecution against Mr. Galloway. So let's not forget where this all began, by a cover-up of a violation of privilege that was knowingly done by law enforcement. Thank you.
You're welcome. All right, I will be issuing a written opinion. I know that's shocking to you. Thank you very much. Thank you,
Judge,
deputies.
I have one request before we
Yes.
adjourn for the day. Thank you for entertaining it. Based upon the court's order from yesterday late afternoon on the newest suppression motion, we are going to make an oral motion for a temporary 21-day stay. If we appeal that decision, it would have to be 21 days from yesterday when it was filed by the court. And because we have not had a chance to really fully digest it and analyze it and see if is an appeal even appropriate, we don't want to take a knee-jerk reaction and simply file a motion for a stay right now and delay this unnecessarily. But we do want to take a look at it and be able to say within 21 days, is it appropriate for us to appeal it and risk delaying the case even more? And so we'd ask just for a temporary stay on that issue for 21 days. If in fact we decide to appeal, we will formally file another motion for our application to the court.
I will not entertain that kind of motion orally.
Okay. Thank you. We will file
You're
a
welcome.
appropriate document. Thanks, Judge.
All rise, please.